of you. I am the division head for learning services, but I'm also the scholarly communication librarian for Arizona State University Libraries, which means that I specialize in copyright, fair use, scholarly publishing, and all things open. So this is one of my favorite things to talk about, especially copyright. I do have to give a little caveat, which I hope all of you expect, is that I am not a lawyer, and so nothing that I am talking about today should be taken as legal advice. But as a librarian, I can give you good sources of information and know that it's authoritative and accurate. So we can start with that. So in today's workshop, we have some goals in that I'm going to provide a brief overview of copyright. We'll talk about how copyright works with the things that we do in education and which tools of copyright are at our disposal in order to help us do the work that we need to do as educators. We'll talk a little bit about how copyright fits into open educational resources and that whole concept. Talk a little bit about Creative Commons as a tool of copyright, and then we'll have a little interactive activity. And as Matthew said, there's a few points throughout this presentation where I'll pause and take some questions. Okay, next slide, please. So I think that many people, perhaps most, have a lot of fear, uncertainty, and doubt when it comes to copyright. We're told to respect copyright. We're threatened with enormous fines every time we play a DVD at home, given dire warning never to copy any portion of anything, no matter how small, at the beginning of many books. But how many of you have ever received any actual education about copyright? And whether or not you yourself are a copyright owner. So can you use the reactions function to do a thumbs up if you are a copyright owner? Let's see if we can see this. Seeing lots of thumbs up. Anybody say thumbs down, not a copyright owner? A few of you, okay. Okay, hey, I like these reactions. They're working out great. So we will talk about that a little bit later, but this is one of the really common misunderstandings about copyright in that, look, if you make any kind of content that is kind of creative, and especially and including, like a really obvious example is you take pictures on your phone. If you do, you own copyright in those pictures and in other types of work like that. And we'll talk a little bit more about that as we go along. So, and then, okay, so maybe we have the next slide, please. So I'm going to ask another, because I'm having fun with these reactions, let's have one more thing. True or false? Here's your pop quiz. Everything on the internet is in the public domain. Do a thumbs up if true, thumbs down if false. Seeing a lot of thumbs down. Excellent, excellent. Anybody have a thumbs up? I'm not seeing any. That's correct. Congratulations, all of you. You've already gotten your first gold star. It's true. Not everything on the internet is in the public domain. There are, part of the reason I share this is because I had a full professor call me on the phone and say, well, I can use anything on the internet. It's in the public domain, right? And, you know, I had to have a conversation with somebody who is quite a bit more senior to me and experienced about how that's not the case. That just because something is freely available does not mean it's in the public domain. And so we'll also talk a little bit about the public domain in this session. Next slide, please. So I think it's helpful as you start thinking about copyright to understand where it came from. And here's some of the original copyright basics. Copyright in the United States began in our Constitution in Article 1, Section 8. It is established as one of the powers of Congress in order to promote the progress of science and useful arts by securing for limited times to authors the exclusive rights to their respective writings. And obviously what I've highlighted in bold on this slide is emphasis added. They weren't bolded, although the capitalization is accurate for that time period. So the key phrases here is there's an actual purpose for copyright. The reason for this power and the reason for copyright is to promote the progress of science and the useful arts. And then there's some guidance here on how to do that, which is providing incentives for people to create by allowing them to have a limited period of time where they have the exclusive rights to their work. So it's essentially the exclusive right to make certain uses of works for a limited period of time. So this really defines what copyright is. Next slide, please. So what copyright law that we currently are under is the Copyright Act of 1976. And in that, it defines what's eligible for copyright protection as original works of authorship that can be fixed in a tangible form of expression. So the original aspect is there has to be a certain amount of creativity or originality to a work. It has to be authored. That's another actual piece that will become increasingly important, as we'll see in some of the examples we talk about later. And it has to be fixed in a tangible form of expression, which means that it has to be recorded in some way in which it can be reviewed and seen again later or perceived at some later date. And so that could be a hard drive, your phone, a piece of paper, a canvas, or street art like our young artists here on the slide. So copyright also applies automatically, and this has been a change since 1989. There's no registration required for copyright to apply. As soon as you fix a work in a tangible form of expression, take a picture, finish writing an article, complete a sketch, copyright applies. You don't have to do anything. Now you can choose to register your work with the US Copyright Office. Then there's reasons for doing so, but that is not required to ensure copyright protection. And the current term of copyright is the life of the author plus 70 years. So, for example, if, let's make something super easy. I mean, if I died tomorrow, all of my copyrighted works would not enter the public domain until 2092. 2092. That's a long time for copyright to protect a work. Next slide, please. So, and there are also some specific types of expression that are specifically mentioned as having copyright protection. So here's the list of forms of expression that are listed in the US Copyright Code. And I won't read them all out to you, but you will notice that, a lot of the things that we expect there, but there are also things like pantomime and choreography. Those are forms of expression that are protected. Architectural works are protected. Okay, next slide, please. But there are a lot of things that copyright does not protect. So copyright protects expression, but not ideas. I can have an idea of a story I want to tell about a young person who has suddenly gained extraordinary powers and must now defend the world from a previously unknown evil power. But until I express that idea, until I tell that story through a novel, through a movie, poetry, or music, it is not protected by copyright. Copyright also doesn't protect facts, no matter how much work it takes to compile them. So there's a very famous copyright case which involved a phone book, where one company copied the entire phone book of another phone company and added onto it, and then was sued for copyright infringement. The court ruled in that case that even though it took a lot of work to create the book, they called it the sweat of the brow, it was not sufficient for copyright protection. A phone book is merely a listing of people, where they live, their phone numbers, and it's arranged in alphabetical order. There is no creativity or originality involved. There are also types of other types of things that are just facts, but then that means that, for example, a lot of data are not protected by copyright. If you've got an Excel spreadsheet that has a lot of recordings of instrument readings, experiment results, they're essentially factual representations of a specific condition or observation at a specific time. So that is also not protected by copyright. And we kind of see that in the example on the right, this table of facts. These are just things that were like statistics. That's what it was in those years and for those specific things. There's no copyright protection there. There are also other things that are not protected by copyright, such as names, titles, short phrases or slogans, or mere listings of ingredients or content. But some of these may be protected by trademark law, which is a different branch of intellectual property and which does require registration and notification to apply. So you can't have a trademark in something and not know it, because you have to have taken the action of registering your trademark and having it be approved and granted. Other things that are not protected by copyright are ideas, processes, procedures, methods, concepts, or devices, as distinguished from a description, explanation, or illustration. Those are not protected by copyright, but that may be protected by patent, which is the third branch of intellectual property law, and which also requires notification and registration. So you have to have gone through the process of applying for patent in order for something to be protected under patent law. And finally, work that consists entirely of information that is common property and contains no original authorship, such as standard calendars, height and weight charts, tape measures, rules, tables, etc., that are taken from public documents or other common sources. So that's why I have this picture on the left of this calendar where it says copyright 1997, Houghton Mifflin Company, all rights reserved, but it's a blank calendar. There's nothing that could be protected by copyright in this situation because it's just a grid of the days of the week arranged in weeks of a month. I mean, there's only so many ways you can represent the days, weeks, months, and years. And how do we, manage calendars? So that kind of stuff cannot be protected by copyright. Okay, so next slide, please. So I said we talk a little bit about the public domain, and this is a specific category of works that are not protected by copyright. Public domain materials include content for which copyright protection has expired. So as of this year, we're at a point that materials published in the United States in 1925 or before have all entered the public domain. So that's pretty exciting. Each year, actually, part of the reason I say it's exciting is that each year now, starting in 2019, at January 1st of each year, there are new works being entered into the public domain. We had about a 30-year gap between 1989 and 2019, where there was no new works entering the public domain. So that was kind of a new and exciting thing. So for example, Rhapsody in Blue entered the public domain this year. And then in addition, public domain works also include works that are created by the US federal government, like this photo from NASA. Okay, next slide, please. So what does it mean to have copyright? Copyright is a bundle of rights. And when you do have copyright in a work, it means you are the only person who has these exclusive rights. You are the only person who can reproduce or make copies of your work. You are the only person who can distribute or share your work. You're the only person who can create derivative works, such as taking your novel and turning it into a screenplay, or taking some poetry and turning it into a song. You're the only person who can publicly perform and publicly display your work. So within the term of copyright, which for most of us is, right, 70 years after the death of the author, the author's permission is needed to do any of these things, unless a limitation or exception applies. So that's an important thing. This is exclusive rights, but there are some exceptions. And we'll talk about those in a moment. But first, can we go to the next slide? A quick pop quiz, because I just bored you with a whole bunch of copyright knowledge. So here's a great copyright situation. You may recognize this handsome crested macaque named Naruto. And Naruto took this selfie with a camera owned by photographer David Slater. Who owns the copyright? And so here, I think you'll need to type in the text. I love seeing all the answers come in here. Okay, looks like there's some folks that aren't willing to take a position, and I understand that. I think we kind of have a 50-50 split approximately of people that say Naruto owns the copyright or that David Slater owns the copyright. And actually, can we see the next slide, please? This file is in the public domain. This work is in the public domain because as the work of a non-human animal, it has no human author in whom copyright is vested. And you may be familiar with this situation. This photo had been posted on Wikipedia's Wikimedia Commons, and David Slater asked that it be taken down. He argued that because it was his camera and he had the relationship with this colony of crested macaques that let Naruto take the camera, that he should own the copyright. But he was not the person that he took the photo or made the creative decisions about, wow, this is a really amazing selfie. But Naruto, being a monkey, is not, one could argue that Naruto herself did not make creative decisions about her selfie. She just got really lucky about taking those pictures. And so copyright does have to be authored by a human. Though I imagine that some things are going to change over the next several years as we increasingly have more intelligent and complex artificial intelligence. We know that you can program an artificial intelligence bot, right, to write a play in the style of Shakespeare. Would that play written by a bot have copyright protection? I mean, you could argue it's creative, but really they're kind of doing this programmatic algorithm of using words and putting them in certain orders. And that's what we do as humans too, but the artificial intelligence has no human author. So that's where it stands right now in copyright law. But as I said, I imagine there's going to be some famous case about it sometime in the near future. And then the Ninth Circuit Court of Appeals did find that because a monkey was the person who took the photo, it had no jurisdiction to bring forward copyright infringement lawsuits. Okay, next slide, please. So as we were talking earlier, when we were looking at the bundle of rights that our copyright authors have, we said that the author's permission is required in order to reproduce, distribute, create derivative work, and publicly perform or display their works. But we do these things all the time with other people's work without asking for permission. So let's talk about the tools or the exceptions that allow us to take those actions. So we have three particular copyright exceptions in education that we're going to talk a little bit more about. We'll talk about the classroom use provision, the TEACH Act, and fair use. So next slide, please. So the classroom use exception is one that most of you are probably familiar with, even if you didn't know what it was called in copyright law. This is section 110(1) of the US Copyright Act, and it allows for the performance or display of works in nonprofit, face-to-face, in-person classroom environments. So showing movies or playing music for a class or sharing purchased or borrowed copies of a book or artwork would be permitted under this exception. And I'm sure that we've all either watched a movie in class when we were younger, or you've probably shown movies in class in your face-to-face teaching situation. But this exception does not cover distributing or making copies or showing things in any other environment other than an in-person one. So not even simultaneous distance education. Like we couldn't show a movie on this WebEx under this exception, for example. Or it does not cover uses in for-profit contexts. And it's important to note that this section of copyright law was written in 1976, and they did not anticipate how technological advances would change the way we deliver content in an individual educational setting. So this is one of the places where the internet broke copyright. Next slide, please. So the TEACH Act was kind of a patch that the copyright that Congress tried to apply to copyright law in 2001. This is section 110(2) of the Copyright Act. And the TEACH Act allows for the public performance and display of in online teaching environments, but still under some very specific conditions. Some conditions are specific to the institution, such as having an institutional copyright policy and using certain technologies, such as making sure you have a really good learning management system so that only enrolled students can participate in the class. And some of these conditions are at the discretion of the instructor, such as the material must be required course content, and they can only use reasonable and limited portions. And you have to include a copyright notice of the work that you're using. So it has requirements that are institution specific, which is part of the reason we're not going to go into it in detail, because we come from a variety of different institutions. But there are some resources about learning more about the TEACH Act if you think it might apply to some of your teaching situations. But one important thing to remember is that there is nothing in the TEACH Act that fair use doesn't give you more leeway than the TEACH Act does. And I'm going to put the link to this checklist that I included in the chat. Here you go. Okay, next slide, please. So I'll pause here for a minute and see if anybody has any questions so far.
There are no questions in the chat right now.
Okay. I think folks are getting it. If you think of anything, there will be another time a little later on where I pause for questions. So feel free to put in any questions as they come to you, and we'll try to get back to answering any questions as we go along. Okay, next slide, please. So the most powerful tool that we have in our disposal is fair use. Fair use is section 107 of the US Copyright Code, and it is a defense intended to place certain limits on copyright holders to preserve our First Amendment rights of free speech and to promote conversation, and for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. And that's directly quoted from the statute itself, Section 107. Fair use is often called the breathing space for free speech, free inquiry, and the open exchange of ideas in copyright law. And it is intentionally vague. The only way to know absolutely that a use is fair is to successfully defend a fair use challenge in court. Next slide, please. So fair use is evaluated by considering these 4 factors: the purpose of the use, the nature of the work, the amount that you're using, and the effect of the use on the market. All 4 factors must be evaluated, and no one factor is determinative. You can't just stop at factor 1 and say it's educational, so all my uses are fair. You still have to consider the other 3 factors in order to make an evaluation. We'll talk about each one of these factors in a little detail next. So the next slide, please. So the purpose and character of the use is where you consider why you're using the work. Are you creating something you'll sell? Are you incorporating it into a course syllabus or assignment? Is it meeting a specific learning objective? Are you reporting on or reviewing it? Because teaching and scholarship are specifically mentioned as reasons for fair use in copyright law. Those are generally weighed in favor of fair use. But as I said, you can't just stop there. You still have to consider the other 3 factors. Additionally, if your use is transformative, that is creating a new purpose or a new understanding, it is a stronger argument for fair use. We'll talk a little bit about transformative use a little bit later. Next slide, please. So the second factor is the nature of the work being used. Is it a creative work, such as poetry, music, art, or dance? Or is it more factual, such as a history book or a scientific article? Uses of factual works tend to weigh more in favor of fair use than creative work. And another element in here is if the original work was ever published, that is, made public by the creator. For example, using someone's private diary is less likely to be fair than if they'd published their memoir. And another thing that comes into this factor is, was this work created specifically for your purpose? For example, if you wanted to use portions of a textbook for Biology 101 in your Biology 101 course, it may weigh more against fair use. Okay, next slide, please. The third factor is the amount and substantiality of the use in proportion to the whole. And an important thing to remember is that there are no specific amounts that are considered safe in copyright law, despite the many guidelines you might see about using 2 minutes of a work or 10%. There are some court cases where using the entire work was considered fair, such as scanning an entire book to enable screen readers or Braille translators to make it accessible. And some cases where only using 30 seconds of a work was not considered fair. So here's the important concept when you're looking at this factor is that you've used only as much as you need in order to meet your purpose. Okay, next slide, please. And finally, the last factor is the effect of the use on the market. And this has a strong impact on whether or not a use is considered fair. Would your use have an impact on the potential market for the original work? Could it be used as a substitute for the original work? And this is very relevant to the work we do in education, since there is a significant market for textbooks, learning objects, and online educational materials. Using textbooks in a class, that's the textbook that it's applied for, not a transformative use. It's the reason that thing was created. And it would affect royalties if we were not charging our students for those works. So while most individuals focus on the amount and educational purpose from factors, the courts weigh very heavily on the purpose of the use and the effect of the use on the market. If your purpose does not weigh in favor of fair use, and it looks like it would have an effect on the market for that work, your entire evaluation will likely not be considered fair use. Okay, and then next slide, please. Lastly, I said we'd talk a little bit more about transformative use. And a final test for fair use, when you're thinking about these 4 factors, are these 3 questions, which better help define whether your use is transformative. If you can honestly answer yes to these questions, it's very likely your overall use is likely to be fair. So is this material needed to help me make my new point? Will my use help my audience understand my new point? And have I used no more than is needed for them to understand? And a lot of the work that we do in education is transformative or can be. So again, we have a lot of, we're starting from a really good place most of the time, but we still need to do this thoughtful evaluation of the uses we make of copyrighted works. Okay, next slide, please. So a really common question that I get is if it's okay to link to something. And this is, yes, it's almost always acceptable to provide a link to something that's freely available online or to use embed codes that are provided by a platform. So if you're embedding a video from YouTube or embedding an image from Instagram, there's nothing wrong with linking to these things or using those codes that are provided by that platform because it is not infringing any of the rights of a copyright holder. You're not creating a new copy because you're sharing the copy that already exists. And you're not making any changes to it because then it's not a derivative work. So when we talked about the exclusive rights of copyright holders, if we're linking to something that's already freely available, it doesn't impact any of those exclusive rights. But I will say that it's not a good idea to link to something that you suspect might not be uploaded by the copyright holder. So if you find the entire movie of Iron Man on YouTube that's uploaded by the user Avengers Fan Club, it's probably not a good idea to use that for your students, because not only is it very likely to be taken down, but it's also not demonstrating good practice to your students. Okay, next slide, please. So at this point, are there any further questions? Or any questions at all, I guess?
There is one question. What is the penalty for a YouTube video sharing? For instance, like Iron Man.
So the way YouTube works typically is that, say I'm Avengers Fan Club, and I rip my DVD of Iron Man and I upload it to YouTube. YouTube has some very active and vigilant copyright bots that patrol everything uploaded to YouTube and try to match it up against previously known content. And they'll flag that thing like right off the bat. And typically the first thing that happens is YouTube just takes it down. They tell you, we have reason to believe that you don't own the copyright to this content, and so you can't post it on YouTube. And that's the extent of it for the most part, because they won't let you share it. It's possible to appeal that decision. Say you feel that you've altered Iron Man in some way, in a way that you believe is fair use. You could try to appeal that with YouTube, and that can be kind of a process because it takes a couple of layers before you get past the box, right? So you get to a human where you can actually evaluate an argument. But yeah, so typically there's no real penalty other than it's going to get taken down. And if it doesn't get taken down right away, it won't be long before it's taken down. Any other questions?
Not
Okay.
at this time.
Okay, I have a question for you to just, see if you all were kind of listening or paying attention. So let's have a scenario where a professor wants to upload 3 chapters of a textbook to Canvas for her course so that the students will not have to purchase the textbook. The textbook has 12 chapters. Would this be acceptable under fair use? So I'm seeing some great answers here. A good question, is the class online, in person? It's online. We said we're uploading it to Canvas for their course. So yeah, it looks like I would also say that like the main reason you wouldn't do that is because the purpose of your use is to avoid having your students purchase that textbook. And Matthew will tell you that I am a big open education advocate, and I really hate having to charge our students tons of money for their course materials. But unless you have a really good justification, a really good reason for using that specific content in order to make a fair use evaluation, you can't just infringe copyright to upload a variety of chapters so they won't have to purchase the textbook. So if, for example, you used a different textbook, maybe an open text that you use for your students, but there were a couple of things about these 3 chapters of this book that were particularly useful or really good for your students. And say it was out of print, or it's not easy to find, or your students certainly don't need the entire textbook, then it may be that you could make a fair use argument. But having it be specifically so your students don't have to purchase the textbook makes it pretty clear that it wouldn't be a fair use of that textbook. Let's see. I see even in person that would be a violation. If you were showing like if you were in person and passed the textbook around for people to see, that wouldn't necessarily be a violation. And it may be that if you just made a couple of copies of a couple pages that you passed out in person, that would be more likely to be fair than posting it in Canvas, where it's more available and more easily redistributable. And I see there was a clarification about playing the Iron Man video in class. So do you mean that if you showed like Iron Man was on YouTube, posted by a perhaps dubious person, and you showed that video in your class, you would not be the one in trouble because you didn't upload the content. That was the copyright infringement. Let's see. I see. What about a 2-page case from an entire book? Again, the main thing is not how long the work is. It is the reason for the work and whether or not it would be, what kind of work it is and the effect of these in the market. So you'd have to go through all of the different, the fair use factors in order to make a decision. I mean, it's likely that just this one 2-page case would be okay, but you still have to go through these other evaluations that evaluate it against all sorts of the factors. Let's see. Any effort to review or update the laws to reflect today's use of technology with education? They are always making new little things to copyright. And in fact, the end of the year legislative session, the big COVID relief package that was passed in December included specific, included 2 different things about additions, modifications to copyright which did affect some of our uses, use of today's technology. And some are kind of related to libraries and technology, and some are not. It's kind of a long, I'm not going to go into that too much, but I could certainly share a link to some information about that if you're interested. So if you are using library materials to your students, that's always okay. Although most likely, and you may check with your specific, with your librarians at your institution, but most likely, most library vendors prefer you to link to the article on their site, not to download a PDF and re-upload it. So that's not necessarily a copyright infringement, but it may be a violation of their license agreement with that publisher. But most of the time at libraries, we license the works to be used for these educational purposes, but the publishers like to have that linked to the article. And there's another really good reason to do that. If you link to the article, then it tracks the usage of all of your students. And so librarians often use usage statistics as something they consider when they're deciding whether or not to resubscribe to journal articles. So if they see 200 hits of this, article in this journal versus, from all of your students visiting it versus, one hit from when you downloaded it and uploaded it again, they don't really see the real picture of how this stuff is being used. And even though it's not the only thing they look at when they're deciding journals to continue to subscribe to, it could impact whether or not they continue to subscribe to that journal. So I check with your library about what their practices and preferences are about linking to or re-uploading PDFs from library databases. Okay, Alyssa, I will look for a link and send it out a little bit later on. Okay, thanks everybody. Next slide, please. Okay, so now we've talked a lot about copyright, and so I'd like to talk a little bit about how it applies to open educational resources. So we know that when we or others create educational materials, they will be eligible for copyright protection, which means the authors have those exclusive rights of reproduction, distribution, derivative work, public performance, and display. Instructors and students can certainly use this content under certain copyright exceptions. And of course, there is a flourishing market for purchasing or licensing this type of content. But when we talk about open educational resources, we are not just talking about cost. So that's part of it, but that's not all of it. So next slide, please. The most important characteristics of open educational resources is having permission in advance. So if you've been to the previous workshop, you would have learned about the 5 R's: reuse, redistribute, revise, remix, and retain. So those are copyright permissions that you know in advance that you can do these things with the work that you're using. So how do we know we have these permissions? So next slide, please. So we use different licensing standards, and the most famous one is Creative Commons licenses. So we talked a little bit earlier about how the internet broke copyright. And one of the main problems with that is without this requirement to register a copyright or indicate that something is copyrighted, it can be really difficult to know who owns the copyright of a work. I mean, as you know, some of you didn't realize you owned the copyright to your work. And this becomes especially complicated when we're looking at things online. So Creative Commons released their first licenses in 2002 to create a standard set of terms to make it easier for copyright holders to communicate which rights they wish to retain and what they wish to permit upfront. So these licenses are designed to work alongside copyright law to clarify to potential users how they can use, share, and modify their work without having to ask for permission first. So it's easier for copyright holders because they give permission in advance, and by applying that license, they indicate that they themselves are the copyright holder of the work. And it makes it easier for users who know what they can and cannot do with a work without having to conduct a fair use evaluation or see if it applies under one of our other copyright exceptions, or ask for permission. Additionally, the standard licenses are machine readable, which means they can be indexed and searched. And we'll talk about that quite a bit more in our next workshop tomorrow. So there are 6 main licenses, ranging from very permissive, the Creative Commons Attribution license, which is where I could do anything with a work that I want to as long as I provide attribution, to the more restrictive Creative Commons Attribution, non-commercial, and no derivatives, which means that I can copy and share a work as long as I provide attribution, my use is non-commercial, and I don't make any modifications to the work that I share. But yeah, as I said, we'll be talking about those in more detail at the next workshop in our series tomorrow. And next slide, please. But you can start looking for them now as you go about your meanderings on the internet. Here are some examples of what Creative Commons licenses look like in the wild. You can see it on YouTube, on Flickr. There are open access journals that release scholarly content under an Creative Commons license. Okay, and next slide, please. And I always like to include this tool, the Open Attribution Builder, created by Open Washington, that helps you, since all Creative Commons licenses require that you attribute the creator of a licensed material and include a link to the license. It's more important to have a standard way of citing the work you're using that is Creative Commons licensed. So this is one of my favorite tools to make it really easy to comply with the terms of a Creative Commons license.
Okay.
That includes everything that you need in order to have a standard citation. Okay, next slide, please. Okay, so my hope today was to equip you with the tools you need to understand copyright basics, which copyright exceptions apply to education, and how to conduct a fair use evaluation. So we're going to try doing kind of a large group activity. Since there's not a ton of you, we'll see how this works out. But first I want to give you this tool. This is a copyright decision chart and checklist for helping you evaluate copyright decisions. And it includes a copyright decision chart to help you frame your thinking about evaluating the copyright status of a work, a fair use checklist, and some information about Creative Commons licenses. Okay, and then the next slide, please. And I'm going to paste this also in the chat. I have, and this is something that you can take away later on if you want to. We'll see, like I said, we'll kind of experiment with how we might do this in this environment. I'm just going to start, so I have 4 scenarios, and I'm going to read them to you, and I will also paste them in the chat so we can have a discussion. And I think if you can unmute yourselves, if you have something to say, you can. I think, do they have permission, Debbie and Regina, to unmute if they wanted to?
They absolutely can.
Okay, great. So the first scenario that I'd like to present to everybody is an instructor wants to scan the entire play of Shakespeare's King Lear from a copyrighted anthology and upload it for supplemental reading to his British literature course. So can he do this, and why or why not? So Shannon has a good question. Did the publisher add anything to it? That's a good question. So see, I like to share these scenarios because these are things that really happen and are important things to consider. But this also kind of gives a little bit of insight into like all of some of the maze that we navigate as we're looking at work. So Shakespeare's King Lear is in the public domain, and you can't take something from the public domain and like just republish it and say, oh, now it's copyrighted again. So that text of King Lear is in the public domain. However, if this anthology has a lot of annotations or in-text, things, commentary, all sorts of things about the use of the language here, or these particular things, those annotations and that kind of additional content could be protected by copyright. And so I see Angela mention that she would look for the public domain content. And so as long as all they needed was the text of King Lear, why not use one of the many versions of King Lear that are available in the public domain online and make it easier for your students? If there were a specific reason that you needed the commentary or annotation for that copyrighted anthology, then you would need to make a fair use evaluation. Okay, let's do, I'm not going to do all of these scenarios. I'll do one more scenario here, which is one of my favorites. So what if a biology instructor wants to use a funny image of a cat they found on Google Image as an icebreaker for an online course? The image is not related to the topic of the course, and the instructor does not remember where he got it. Can he use this picture, and why or why not? I see a couple of no's. Risky. I like that. And I did too, Angela. And I think that that's part of the, this kind of plays into it as well. And Shannon, that's a good question. We said an online course, so this would be part of the Canvas page. But you're right that if it had been in person in an in-person nonprofit educational setting, you could put up a funny cat picture on the screen to your face-to-face students, and that would be covered under the classroom use exception. But in the online environment in Canvas, you wouldn't be able to use it. Yeah, and you wouldn't need to provide attribution necessarily in the face-to-face context. But I think, here's where it's like the professor doesn't know where they got it, so they don't even know who the copyright holder is. So they don't know if it's available under an open license. They can't provide attribution to it. They just don't have a real legitimate reason for using it. And a fair use evaluation would be pretty weak because it's just kind of there, not for an educational purpose, but for something funny, like on a slide, like I have right here, right? So I think that, the key guidance I would give to an instructor in this situation is, why do you need that funny cat picture? There are millions of funny cat pictures online, or you may have your own funny cat picture, as Angela said, that you could use in order to meet your purpose here. And again, you could specifically do a search looking for openly licensed funny cat pictures to use for your icebreaker. Okay, so I hope that these were just a couple of useful examples for you of kind of some ways to apply copyright to some common situations. Can we go to the next slide, please? And I think, you know, these two were sort of easy ones. There are a couple of others on the document that I shared that might be fun to look at some later date. And next slide, please. So one thing that I want to make sure to share with you is that here are some other sources about copyright and Creative Commons information. I have a library guide that I use to help provide guidance around copyright, which you can see the URL here, and I can also paste that in the chat. And Creative Commons. And I have already shared the decision chart and checklist. So hopefully these can be useful resources to you later on. Let's see. Oh, Catherine, the monkey scenario. So if a person took the picture using David's camera, the person that took the photo would be the author and the copyright owner. So, you know, think about all the times when you're like on vacation and you hand somebody your camera or your phone and you're like, hey, take a picture of us in front of the Statue of Liberty or something. Technically speaking, they own the copyright to the work that they took that picture of you and your you know, traveling partners or whatever, which sometimes makes for some awkward, like I sometimes have some awkward conversations if I ask somebody to do that. I'm like, hey, thanks. And will you give me permission to use, share, and do anything I want with this picture moving forward? Like, if they say yes, I'm like, okay, cool, we're good. So, no, if you use the self timer and it's your phone, like technically nobody's doing it, but you typically do some positioning of the phone at that time, right? So yeah, it could be the person who set the timer, but, and again, like most people don't even know this, so I wouldn't worry too much about it. Unless it's like the person you hand your phone to happens to be a professional photographer who's like super aware of all of their copyright permissions, but they'd probably tell you, hey, send me a copy of this and I own copyright to it. So anyway, those are some kind of fun things to think about. And next slide. This is essentially the end of what I've prepared to talk about, but I'm happy to have some discussion and comment or, you know, any further questions. Oh yeah, you know, there's a term for that, for often revenge. Yeah, so yeah, that was kind of tricky because she would have owned the copyright. I mean, him posting it and sharing it publicly would be an infringement of her copyright, but it's also an infringement of her right to privacy, which is kind of a separate issue outside of copyright. There are certain aspects of the law that are, you know, people should have a certain expectation of privacy in these kinds of situations. I think when they originally created that kind of those laws, they didn't imagine how people were going to be sharing content on the internet in like really public ways, how easy it would be. And so there have been new laws that specifically address those kinds of situations, yeah, revenge porn. But technically speaking, that would be a copyright infringement. So she could sue him for copyright infringement and violating her right to privacy. But this is also like a side note, because everything's about copyright. In order to sue somebody for copyright infringement, you do have to register your copyright in that work with the Copyright Office. So that's one of the reasons why you might want to take that particular action. To, you know, if you have some work that you actually are concerned about kind of keeping some control over future uses, like really asserting your copyright, like if you wanted to sue somebody for copyright infringement, you would want to take that step of registering your work with the US Copyright Office. And you can do that online at copyright.gov. I wouldn't say it's a simple process, but it is a process you can do online. And they're getting better at making that a little bit easier. And I think, you know, and there's a filing fee for the work that you register. So any other comments, questions, fun copyright situations? I'll dig up that that summary of the new copyright things here real quick.
I have a question.
Okay.
We are trying to be very careful with our live guides, and we want to share images from indigenous populations, but there are just not, there are very few for some groups, and they don't necessarily tell you who owns the copyright. Is there a way of sharing these safely and respectfully?
Yeah, that kind of thing is you're navigating a few different complicated situations there. There are some, so it's, and again, it's kind of like, it's not just about copyright here. Like you could probably assert some sort of rights of some of these images, like maybe whoever, and again, that gets kind of tricky. Like sometimes folks give stuff to the library as a donation and we add them to our collections, but they may or may not have owned the copyright to the work they gave us. And they may or may not have given us copyright to the work that they gave us. There are a few different groups that are kind of working with indigenous peoples of around the world to talk about how do we have these conversations and be respectful and educate and respect people's copyright together. And so, okay, I may need to do a little bit of Googling here really quick, but I know that there's a few groups that are having these conversations. And I think one of the important things that you need to remember is like, maybe this isn't where you're like, just because you can do something doesn't necessarily mean you should. Even if the law is on your side, maybe it's not a good idea. Maybe it's a better idea to have a conversation with that community and see how they feel about it. And so, and this is definitely something that in archives, especially in archives and special collections, folks are really kind of digging into this conversation right now about, maybe we shouldn't have posted this stuff. Maybe we should take it down and think about it a bit more. Oh yeah, thank you, Matthew. Okay, if a website says their content is free to share and redistribute, but doesn't use a specific license, would it be open source? I would say no, because just because you can share and redistribute something doesn't necessarily mean it's fully openly licensed, right? What if you wanted to make modifications to it? What if it's a commercial purpose? We don't necessarily know. Some websites say their content is like sort of in the public domain. Okay, sorry, like Unsplash, they use a copyright CC0 license. Okay, here is a summary from the Copyright Office about the changes to the CASE Act of 2020 and a law regarding unauthorized streaming. Let's see. And I will, I'll agree with you, Catherine, in that, and here's something that I like to share, because sometimes, people come out of this workshop and they're like, oh, I'm doing everything wrong in all my courses. I've got all this stuff. And, for a lot of us, our risk is pretty low, right? It's not, we've been doing some of this stuff for a long time, and it's not like all the content providers are, really able to see everything we're doing, especially for courses that we're just kind of keeping to our students in Canvas. It's unlikely that it's going to get out there very far. But I think a couple things to keep in mind is that, well, one thing, we do want to do what's right. We want to respect the rights of copyright holders, and do use works the way they were meant to be used, and use things in their correct context. And then secondly, as we start creating more open educational content, and here's something, at ASU, we're having a big conversation about having kind of MOOCs. We don't call them MOOCs, we call them open scale courses, but we're using like Open edX as the platform, and we're designing these courses, and they're going to be like open to everybody in the world. Well, you need to make really conscious and thoughtful copyright decisions about what you put up there, because it is available to everybody in the world, even if they have to take that active step of registering for free, right? But it could be legitimate, available to anybody in the world for no cost. And so you have to think about downstream uses of some of this work. But I wouldn't, I kind of try to get you to think about, just take things one step at a time. Maybe next time you're doing a course refresh and you've got some funny cat pictures in there that you don't know where they came from, maybe look, replace those with new cat pictures that are openly licensed or that you took yourself. If you've embedded some PDFs that you got from your library and you suddenly went, oh my gosh, what if they, stop subscribing to this journal I use all the time because I did that? Well, maybe next time you do that refresh, do a link to that particular article instead. So again, you can, this doesn't have to be like a complete overhaul of everything you've ever done. It can be something you just take a step at a time, and do kind of think about how most of the time there's really nothing to worry about, other than we just want to do best practice, model good behavior to our students, and hopefully make thoughtful decisions about respecting the rights of copyright holders. It's hard to give this kind of like speech when you don't see everybody. It's not quite as fun.
Okay, well, thank you very much for your presentation. Does anybody have any final questions or comments in the chat? There is a link to the evaluation and assessment on the conference website, and I'm going to go ahead and put that in the chat for you. And Matthew, did you have any final things to say?
No, just thank you everybody for coming. And just as a reminder, there is an Arizona Regional OER Conference social hour at 4 p.m. in 48 minutes. If anyone is interested in joining just to hang out informally. And that's it.
All right, thank you very much. And we do ask that you complete the evaluation and